Make sure you're mute. So
hey guys, I'll give just a minute more for some joining. I apologize about being delayed. Okay, all right, I'm gonna get started. We'll see if anybody else can join up with us as we go. Wanted to do a little bit more what I consider case-oriented talk today. Talk a little bit about error preservation, Rule 59 and Rule 60. These are all super important for you guys doing trials and trial work. And when I look around on this screen, just about all of you are going to be spending some time in trials. So knowing that, you're soon going to be dealing on some level with appeals and what to do when trials go wrong. Now, generally speaking, when you are going through trial, you are going to be thinking about all the things we talk about in our trial talks, and that is that you're going to know your case, you're going to have a very brief theme, that you're going to be able to explain that to a judge, that you're going to be able to win in the back of the in chambers or wherever that might be. So you're not in that situation of stressing out in terms of your trial. We talked a little bit about objections and things like that you might make in trials, and of course where that strategy is in terms of your opening, your closing, and just your overall case strategy. But one of the things I think that we tend to forget about when we're dealing with trials is that in that trial, you have different audiences. Your first audience is your client. I mean, you want some of the things that you're going to do in trial are solely for your client. Your client needs to hear it. Your client needs to hear that their arguments are being posted, that they're being explained in those things. The second one is, of course, the judge. And then, and that can include the jury. But there is a third one we don't talk about that much, and that is the Court of Appeals or your appellate review. And this does happen more than you think. And there's a couple of different times where it does come up and you want to be able to deal with it pretty quickly. So, starting with that, I think the very first thing to talk about is your error preservation strategy. Now, one of the issues that we have in terms of our trials are that the judges that are running our trials have strong feelings about the case. Most of the time, whether you're in North or South Carolina, you're dealing with a child custody case, you're dealing with a family law case, you're dealing with something that the judge has already got some predisposition or some thoughts about what that case is going to be or what it's going to come to. And quite frankly, a lot of those judges are not going to let the rules of evidence get in the way of hearing the case they want to hear. Melanie and I just got finished doing a hearing, and then we went over to the Rutherford County courtroom and got to see just briefly some jury trial. And it was interesting just to see how Judge Bell from Charlotte was ruling on the motions. It was a criminal case with the public defender's office, and just get to hear a little bit about how the judge was ruling on their evidentiary motions. And was really allowing some things in that I'm not sure that should have come into the trial. Like, well, go ahead, I'll hear that, whatever it is. It's hard to know for sure when you're just watching a trial as to why a judge may allow evidence in and not, because there are some issues in pretrial and things like that that might have some impact on it. But for the most part, evidence was coming in that I think at least it was somewhat questionable whether or not that evidence should have come in. It was things about what a child might have been feeling and things like that. But why is that coming in? The problem is when a judge lets something in, you have to make a decision. Okay, do I object to it or not? Most of the time, you guys are going to say objection. And most of the time, whether I'm in North or South Carolina, when we say objection, that's all the judge wants to hear. The judge doesn't want to hear objection hearsay, doesn't want to hear objection assumes facts not in evidence, objection multiple. Now, there are times in which I will go ahead and say that. I will say, Your Honor, objection on this. Gabby and I right now are dealing with an appeal, and there was an evidentiary issue involved in it of whether or not an expert was going to be able to testify as to a line of issues. And when this happens, the judge was allowing us to go pretty far towards the line, but then a line got drawn and said, you're not going to go any further than that. So what you have to do in the trial, even though you have everything going on, you have a client beside you that's stressed out, you're dealing with a judge, but you're making a record, you have to make an objection at that point. Now, the judge may say overruled, or I'm not, or sustained, or whatever it might be. You have to be able to identify as to why you are making that objection, and you have to be able to do that without making the judge mad or pissed off, because you want to win at the trial court level. You don't want to create a problem. It is fine to say, Your Honor, objection, I would like to be heard. And I've never heard a judge deny that request. So if you say objection, want to be heard on that, then you can say it's hearsay, but it's also statutorily not allowed, because let's say if it's one of our PI cases, Blake might be like, objection, Your Honor, that goes to insurance issue or whatever that might be. So it's not just hearsay that's going on, but it's some kind of secondary issue that's happening. If you don't clarify that, the Court of Appeals will make an assumption as to what that objection was about. And that's not where you want to be. You want to make sure that you're very clear as to what that's going to be. Now, it's during the case, you want to be able to come up with a response that the judge can hear and take into account, and then make a ruling on it. So the order of events is going to be where you have to first of all state, okay, number one, you got to make sure you have to clarify as to what information, evidence, or testimony that you are trying to keep out of the trial, or occasionally proffer. So if you're doing your best job, say, objection, Your Honor, all of that testimony as to what the child was saying is hearsay. Now you've clarified what you're objecting to. So maybe even goes a little bit beyond what that question is. Maybe even goes into whatever the next question might be. But you're making a record saying, I'm objecting to that. You have to make sure that there is a objection as to what is going on. Number two, you have to make sure that the objection is made in a clear format and it's noted for the record. Okay, so you had to say objection, you have to make it very clear, objection, I'm talking about this information, and I believe that the child's testimony is hearsay and should not be allowed. Or if it's an expert witness, you may say, objection, Your Honor, the expert is testifying as to something that goes beyond what their expertise is. They may be an expert on for psychological evidence in terms of what was going on in the client's mind. But if they start speculating as to other actions or other things that may have been done, you can object to that and say, Your Honor, that goes beyond, that's hearsay, and it goes beyond what that expert is involved in or was tendered for. So you can make multiple objections. You have to be very clear about that. The third one, and I know it sounds crazy, but you have to obtain a clear ruling from the court as to the nature of the ruling and the basis of that ruling. So you have to be able to say, you have to wait for the judge to make a ruling. And it doesn't need to be a ruling like, I want to hear this, or we've talked about this. You want to say like, okay, Your Honor, are you sustaining the objection, or whatever that may be. You want to do this in a very open format, but you are setting up later, because believe me, Gabby can explain, and Blake was doing work on this. When you are looking at that transcript, you need it to be very clear as to what was objected to, why it was objected to, and why the court is overruling it. Because courts will not give you a lot of explanation as to why they sustained the objection or they denied the objection. So you have to be able to preserve it, and then you have to indicate all the things that you clearly take exception to the decision of the court on record. Now, in North and South Carolina, you do not have to follow it up in saying, I take exception to that ruling. Okay. All you have to do is be clear about your objection. However, it's best, everything that I've read, it is still best practice for you to say, Your Honor, we note our exception on the record and move forward. Okay. So, if there's evidence you do not want to have come in, you need to do all four of those things. You need to identify what evidence you're talking about. You need to make a clear objection and the reasons why you're making the objection. You need the court to make a clear ruling as to why that's an objection. And then, just to be clear, you need to say, Your Honor, note my exception on the record. So now you have completely preserved that issue for appeal. And I know that's a lot to think about when you're going through a trial, but if you get used to it, it can just be sort of commonplace. You think all four of those things need to be locked in for me to make that determination. And you're going to feel a lot better when you're making your appeal later on in terms of what you're going to be going on to. In the North Carolina rule is the rule of appellate procedure. I believe it's Rule 10. And it just says, in order to preserve an issue for appellate review, a party must have presented to a trial court a timely request, objection, motion, stating the specific ground for the ruling that the party desired the court to make if the specific ground was not apparent from the context. It's also necessary for a complaining party to obtain a ruling upon the party's request, objection, or motion. Any such issue that is properly preserved for review by action of counsel during the course of the proceedings in the trial tribunal by objection noted, or which rule of law was deemed preserved or taken without any such action, including not limited to, and it gives into what these specific ones. Now in North Carolina, in a criminal case, State v. Corbett, and that's I think earlier this year, it found that you can make a continuing objection, and you don't have to continue to make the objection if it is fruitless to be able to do that. Gabby and Blake, I think, put a similar South Carolina rule in our latest one, that if it's apparent what the court is doing, the court appeal does not require form over substance. So if you're like, objection, hearsay, and the court says, okay, I'm going to keep allowing the testimony, and the next sentence is, and then the child said, blah, blah, objection, hearsay. If the court on the second time says, I'm allowing this, you say, Your Honor, note my exception to all of the testimony of the child. Then both in North and South Carolina, at least in North Carolina in criminal cases, that is okay. You can make that standing objection, and the Court of Appeals is not going to continue to require you to make those objections. Does that make sense? So, so those are some ways you preserve. Now, when you're presenting evidence and the court has said objection, we're not going to go. I'm not going to allow that testimony. Then you guys, if you're going to be, to me, A+ lawyering, and I've done this a few times, but probably not as much as I should have done, would be, Your Honor, I would like to make an offer of proof. Now, if you're in a jury trial, the jury has to leave during that time, because what you're going to do is you're putting evidence on the record that the court is not allowing in. Now, if it's a bench trial, the judges, in their miraculous way, allows for this evidence to come in, but the court says, look, it's not going to be evidence as to the trial. We're just putting it in on the record. Why are you doing that? That's why the Court of Appeals, if you're trying to get information in that's objected to, you want the Court of Appeals to be able to see what that information is. So they can say like, oh, well, that would have been relevant information, because if the court says objection or sustained, that's not relevant, and you don't put it on, then you didn't preserve it for appeal. The court of appeals is not just going to guess what evidence you would have put on. You have to say, Your Honor, I'm going to make I understand you're substanding my objection. I want to make an offer of proof as to this information. The court is supposed to always grant that. If they don't grant you a chance to put an offer of proof on, you may be able to get a new trial just based on that, because you weren't able to preserve that information. So let's say you're in court in a practical sense. Let's say it's a custody case, and your client wants to put on information about how they're clean from prior drug use and the things that the doctor said to them during the trial, okay, or during their treatment. Well, the attorney on the other side says, objection, that's clearly hearsay. And you say, well, no, I think it's going to be that's subject to to an exception of hearsay, because it's not for the truth of the matter, but it's to show how my client acted after that, why my client didn't go for further treatment, let's say. And it's a state of mind hearsay objection or exception. Of course, says no, that sustains like, Your Honor, I'd like to make an offer of proof. Well, what you've done is you just asked for like a little side road onto the trial, and the judge is supposed to allow you to do that. So then you can put that evidence on as an offer of proof. Now, I think that could be a good, useful thing to get in information, because the judge is now going to hear it. And how do they unhear something like that? So, it allows you to get it in, and more importantly, you preserve your record. And let me tell you what it also does. It puts the judge on notice. You're going to appeal their decision. For better or for worse, if you're putting an offer of proof on, you're pretty much saying that, hey, we're going to be doing an appeal. And I think that's a pretty serious finding in terms of what might be coming on. There's a few other things that I would say that you want to make sure that you get put on the record. Number one, if you are making a motion for summary judgments are appealed all the time. That's actually one of the most common things that are appealed. You need to make sure that every piece of evidence you're using on summary judgment is part of the record. So you need to make sure that goes in and say, like, Your Honor, I'd like to admit the following exhibits, because sometimes I think you do summary judgment, you do it on a motion, and then you just give the judge an affidavit. You want to make sure all of your evidence is on and part of the record, because if you don't put it on the record, then you're kind of screwed over as far as that goes. So make sure you get all your evidence in. If the court's like, I'm not allowing for this, again, offer of proof can work on a summary judgment motion as well. In North Carolina, there's another point that comes up in appeal is State v. Batchelor, which is 2008, but all the Superior Court and District Court judges get this in their manual. So in a CLE, this is something they talk to judges about a lot. I'm just going to read it out, this little short paragraph. The record demonstrates the defendant made a motion to dismiss at the close of state's evidence. However, the defendant did not renew the motion at the close of all evidence, and therefore waived appellate review of the denial of the motion to dismiss. Nevertheless, this is an appropriate case in which to invoke Rule 2 to address the issue of sufficiency of evidence. If we do not review the sufficiency of the evidence in the present case, defendant will remain in prison for a crime the state did not prove beyond a reasonable doubt. Such a result is manifestly unjust, and we therefore are compelled to invoke Rule 2 under these exceptional circumstances. You know what Rule 2 is? That basically the court, in fairness, can suspend the rules of evidence. So all judges were put on notice in North Carolina that says, like, look, even if you think that the attorney messed up by not, and those of you who do criminal cases, just always remember, in civil cases too, at the end of plaintiff's evidence, always making a motion to dismiss or motion under 12C that all, or 55, that all evidence is in, and that the court needs to make a ruling at that time that they have not shown an issue of material fact. And then you renew it at the end of all evidence. So make sure you're doing that if you're on the defense side either way. But if you don't do it, there still is the chance you can just say like, look, we're going to undo this finding. All right, very briefly. Okay, anybody have any questions on preserving the evidence and all the different things that you might be doing during trial? Okay, let me jump on to the other things. Rule 59 motion. Rule 59, you have to do it within 10 days. That's a motion for new trial based on affidavits that can be served with a motion. You have 10 days after a service in which, Rule 59, you do it in 10 days. And then you can, in that 10 days, you can do any affidavits necessary on that motion. When you get the motion affidavit, you get 10 days to respond, and that can be extended up to 30 days. So Rule 59 is something you can make at the end of evidence to set aside an order or court or otherwise. The court can do this on their own, and Rule 59 allows you to alter or amend a judgment as well, as long as you do it within 10 days, and allows some very specific reasons as to why that can happen. And I recently had a Rule 59 hearing where I was able to set aside a equitable distribution case where the one side a pro se person did not file an affidavit, an ED affidavit, and the court ruled in favor of the defendant based on their affidavit. And there really was no excuse, but the court just felt like it was just so unjustly unfair that the court decided to set it aside. It can happen. It makes it somewhat easy when you're able to pull that off. And you can always ask a judge to amend a finding or make changes. I remember one of my cases that I had, big case, civil case. I was against a very seasoned attorney who is now departed from the earth, Jim Bowen. And at the end of the case, the judge ruled in my favor on a construction case and said, well, Your Honor, he was so quick on his feet. He just stood up and said, like, Your Honor, of course, I would like to get the fees taken out of this case, including my expert witness. And the judge says, oh yeah, I'll grant that too. So in a heartbeat, I went from $15,000 verdict to getting $12,000 in fees assessed against me. So even after losing, moving very quickly and being able to think about like, okay, if this thing goes bad, what can I add to this to change this result? And it really, really did make a difference. Rule 60 is very in line with Rule 59. Rule 60 gives you a year, but to set aside an order, but it has to be based on fraud, notice, or let's see, mistake, inadvertence, surprise, excusable neglect, fraud. The judgment is void. Any other reasons justifying operation of the judgment. So you've got several different chances within 1 year to be able to set aside that verdict or that case under those rules, and that gets you a long way towards maybe changing that result. So if a client comes to you and has a consult based on like, hey, I got this bad ruling against me, don't necessarily think that I have to do an appeal. The answer might be, hey, a Rule 59 or a Rule 60 might be the direction that I want to go in order to get the result that I want to get to. Like for instance, if you don't have, if let's say the person did not know that the trial had been calendared, that for whatever reason the case had not been calendared. Allie brought one of these to my attention earlier today. Like, what do we do when the defendant didn't know this case was being heard? In North Carolina, there's a case called Winley v. Dockery from 1989. The only evidence to determine whether defendants had received notice was in the negative. So it's due to trial court to find as a fact the defense did not have notice and allow the defendant's motion entering an order vacated the judgment to be granted. Because if the answer was just, well, there was no reason the defendant wouldn't have known about this, but couldn't prove that they did know about the calendar date, then the court was required to set it aside. So, if your client misses a court date or has missed a court date or something like that, Rule 60 has some very favorable case law to back that up. So if you can get that done, I think that would go a long way towards making a difference for you. Okay, all right, that's a quick rundown of preserving evidence in Rule 59 and Rule 60. So does anybody have any particular questions? Have any of you guys been in a trial or anything else where you've had to make a ruling, or a case where during the trial you had to preserve some evidence? These are all pretty high level court kind of decisions to make, but if you're in trial every time, you're going to be held to the standard to be able to do that. And I think we do a pretty good job in terms of that. All right, any questions? Anything else might be going on? Sorry about the brief delay today, but I like to go through these, and sometimes I like to just break it down and do some pretty clear case law. This is a CLE I'm going to be giving in November. So if you have any questions about a case where you're at that post-trial motions or trying to think about an appellate stepping into appeal, just let me know. Other than that, I will see you guys soon.